of Ohio.
Tucker?
Yes, Judge, we'd be asking for $1,000 signature bond on each charge for a total of $2,000 with conditions no further contact with, with Natasha Jackson and to stay away from 3400 Norman Berry Road in East Point. The facts allege that this defendant resigned from working there and walked into this victim's office calling her a bitch. He grabbed her by the shirt and the tussle ended up with her on the ground, him putting his knee on her chest while banging her head against the window seat. We did speak with this victim. She said they were co-workers. She confirmed the events in the warrant, said they've had verbal arguments in the past, but it has never gone this far.
It's your basic take this jab and shove it.
She sustained a swollen wrist, swollen knee, does not want any contact with this defendant and wants him to stay away from this location because she still works there. She did let us know she'd be on the Zoom if we could sound for Natasha Jackson.
Ms. Jackson, I see you there. If you would like to address the court, now is your opportunity. I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in.
Hello.
Yes, ma'am. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do. Yes.
Okay, you can place your hand down. What would you like to tell the court, ma'am?
The only concerns that I actually have is that he was a general manager here that relocated, so he actually stays on property. So he still have to come. He still have his vehicle on property and a lot of his personal belongings, which are in the room. So I just ask that at any time that he's coming to the property for me to be advised, and either I not be here or to ensure that he's escorted to the property or have his family, because I understand that he do have family in the area that can come versus him coming to the property.
Okay, if he does come back to the property, I'll have him. He'll have to come with a police escort. Okay, Ms. Jackson. All right. Anything further, ma'am?
No, that's it.
All right. I appreciate you being here this afternoon.
Thank you.
Yes, yes, Mr. Geddes.
Yes, thank you, Your Honor. This defendant is 40 years old. My understanding is that he did relocate to Georgia as part of his taking up this position. I have already discussed with him the possibility of a stay away and no further contact with the alleged victim in this case. My understanding is that he does have family in a separate location that he would be able to stay with. So if the stay away is necessary, there are already things in place that we understand the state's position on that. My understanding is that he does have a bachelor's degree in hospitality management. We do think the UJR would be appropriate, Your Honor.
Okay, for each charge, it'll be $1,000 signature bond through pretrial level 1, makes for a total of a $2,000 signature bond through pretrial level 1. No further contact with Ms. Jackson. Stay away from the Norman Berry Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings, no drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Thank you, Your Honor.
You're welcome.
All right, position 20.
All right, I got to thank Alyssa and Lakificence Lair for hooking me up with this and more clips. This is good stuff. It takes a minute to develop if you haven't seen it yet, but it's worth it.
So you may want to, you may want to push that mic.
Oh, I'm sorry. This one?
Go ahead. While you're talking to him, you hold the mic, but I didn't.
Okay. Did you have other one? Is this your last one?
I only have one other case, but I'm not passing it.
Okay. You said just hold this down?
Yes.
Okay.
All right. Back on the record in this case. All right. Ready?
At this time, the people who said it's 25,000 without the 10%. In this case, The defendant has a companion case in misdemeanor court 1482 from 2024. It's a DV and assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim, and we'd be
exciting and new.
asking that at this time his bond is set at $25,000 without the 10% into custody, Your Honor.
Response.
Okay, regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through that evidence and possibly at that point we can, address bond again at that hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
And Your Honor, I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, your phone was. Let me give you the iPad. It is my understanding that he is gainfully employed. He is a father. I would ask if he can remain out on bond with a tether.
Well, but I'm a bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day.
Mm-hmm.
But he's arraigned on the 4th, and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Yes. Would we be provided with the calls?
Yes, awesome.
Okay.
I'll send the email to have those released today.
I'm going to set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the $25,000 with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's going to be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked so that he'll go into the jail. He won't have phone privileges is the court's intention. And then you can get those through with your client and we can figure it out next week. But at this point, defendant's remanded.
Okay, that was reasonable but necessary. Don't worry, it's about to get worse.
Court does call the case People versus. I'll recall the matter of the People versus Rashad Young.
Alexander, on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like,
Ashley Moulton on behalf of Mr. Young.
yes, and Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So we could get her. Your name?
Tandiana Yates.
All right. Ma'am, I'm going to let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up and you probably would have been locked up. I'm just going to let you know because you don't come into the court that way, ever. Am I clear?
Yes.
All right, I'm curious. I guess she came in earlier and made a jerk of herself. I couldn't find it. But don't worry. She makes a complete jerk of herself again.
Did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that.
Mm-hmm.
I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has a, yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm just going to let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court.
because I feel like it
will-
was inaccurate.
I will listen to you. I'm not going to tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I would never do that, but I just noticed when I was looking on the Zoom that it was inaccurate information.
I would never do that, except I just did it 20 seconds ago. Oh, the poor thing. And she really struggles with the English language as well.
Stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this because you kind of blurted that out when you had come busting in here.
And my apologies for
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here.
No, this is the alleged victim. This is who he was with, as far as I can tell. This is the ugly truth. I've been a prosecutor. People don't like to talk about these things, but this is what happens. So this guy's calling her 135 times, and there's no excuse for that. He's in the lockup where he belongs. But now she wants to undo it, which is, frankly, more the norm than the other way around.
His counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, someone can call my phone so we can discuss this? Because I no longer have that cell phone number, and it was to my sibling. You guys stated on.
If there are references to the case, ma'am, we thought about that.
Oh, sweet Jesus. This is my second time through. So she's saying, I don't have the phone. It's no longer my number. Bullshit. And he's saying I wasn't the one making the calls, and they traced the calls to his cell. So they're in this one together. He's making a call from his cell to the phone number he had of hers when he was incarcerated. And now she's trying to say, I don't have that phone. I gave it to my sister. Oh my God.
Okay.
There are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily what is being represented to the court appears to be true. And we will flush it out at a hearing because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week regarding that.
But how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I couldn't even be around him.
I am not going to have a hearing on it right now. I will listen to you.
That's just that was just very inaccurate to me, and I just felt like the way that y'all did that was no. Somebody should have.
Y'all did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No.
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
Nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem.
And now my whole chat's jealous of the victim.
Ms. Cannon, do you want your cases called now? No, I'm good. I am so good, Ms. Cannon. Are your people here? Oh, well.
Yes, Your Honor, they are here. They are ready and they are eager to just listen and learn from this honorable court.
Is live from the Royal Oak Jail.
Oh,
with
fun.
regards to the arraignment, we would waive a formal reading
This is Alyssa's fault. This one's just a straight whack job. It's fun.
enter a plea of not guilty at this time, and court-appointed counsel is requested.
Thank you very much. Ms. Johnson, I appreciate your effort and your professionalism. So you understand today's just an arraignment, okay?
Her professionalism? What the hell are you talking about, Judge? Well, I've had the benefit of seeing more of the hearing, but there's no professionalism involved. I mean, nothing even close.
The court is entering, Ms. Johnson, a not guilty plea. Repeat, not guilty plea on your behalf. Court-appointed counsel will be noted and approved for the future. Ms. Johnson, are you still around?
Hey, Chuck, I'm right here. You want to see me?
Ms. Johnson?
Yes, Judge.
Yes, we're not quite done yet, so stay with the court, please. You'll be getting a notice to your Washington address that'll direct you when and how to appear for your next court date, okay?
Okay, Judge.
All right, and in the meantime, the court has to consider the issue of bond. That's not meant to punish you or prejudge you, but the court has to set bond to make sure you come back and to afford any necessary protection to the public or to yourself. In that regard, Ms. Miller, would you like to take the floor as to bond?
Yeah, I don't believe that my client has any kind of criminal history. I think this is an isolated event. I would ask for a personal bond on her behalf. I have no doubt that she'll come to court, and I'd like to see her be able to leave the jail today.
Well, thank you. Ms. Johnson, you will get all of this information in writing, but these conditions will apply to your release. You will appear as directed for all your future dates. You'll abide any valid order or judgment entered in this case. You will not leave the state of Michigan without permission of the court. Please don't commit any crimes on release status. Please notify the court in writing of any change of address, telephone, or email. We are going to be supervised by pretrial services. No alcohol, marijuana, or any other controlled substance without
And by we, I mean you.
a valid prescription from a treating physician. You will participate in a substance abuse testing or monitoring program. You will participate in any specified treatment program for any physical or emotional condition if that is ongoing.
I'm listening, Judge.
Thank you. No purchase or possession of a firearm or other deadly weapon.
Okay, crazy.
Do not have any contact with the 6th salon. So you might have to choose a new salon.
I'm thinking the 7th.
I'm still listening, Judge.
Thank you. And you will be tested for alcohol 2 times a week with an ETG. There will be an initial drug screen. If it's negative, there will need be no further testing.
You better promise it all will happen, Judge. You promise it all will happen, right?
And if it's positive, you'll be tested for controlled substances 3 times a month. At this time, the court will set a $2,500 personal bond. What that means, Ms. Johnson, is you don't need to post that money to go home.
Okay.
But if you miss a court date, if you violate a bond condition, if you start ignoring rational legal advice, you could end up owing the court $2,500 and a bench warrant could issue for your arrest. So we're going to hope that this is just a mere hiccup. And with that, Ms. Miller, is there anything further?
No, thank you, Your Honor.
All right, Ms. Johnson, that takes care of your arraignment. Good luck to you. Once your BAC, once your blood alcohol content comes down to a safe level, the officers will be free to let you go at their discretion. Take care.
Oh, wait. I didn't have that nugget right there. Where is it?
Take care.
That's as close as I can get. She goes all the way, but it's real quick, and then it clips out.
And in the Nisqually jail, sir, what is your name, please?
Oh, we've got another contestant in the Big Dummy Olympics. This guy, he's right up there with the last one. I didn't realize the last one was drunk. I just thought she was crazy. The judge is like, we're going to wait till the BAC comes down. It's okay. People have done it for me too.
Alatorre, Your Honor. Thank you. Your true name is Adrian Nicholas Alatorre.
Yes, Your Honor.
Your date of birth is February 26, 1987.
Yes, sir.
Thank you, sir. You're before the court under 2 cases. Cause number 1685 is on for a stipulated order of continuance review. The cause number ending in 0324 is before the court for an arraignment.
Yes, sir. I just wanted to say, first and foremost, I apologize.
Mr.
I apologize for not being able to come into court. Can I talk? I am a grown man.
I'm protecting your rights. Everything that you say on the record can be used against you. That's why I'm telling you.
Okay, I understand that. I understand that. Thank you. I just want to say, Your Honor, before you start, before rudely cutting in, I apologize, and I apologize for you having to write a dragging thing. I'm going through a lot of pain right now in my cell with my body and everything. I'm supposed to be in the hospital, but I don't want to go into depth on that. I just want to say I apologize for having to be drugged in here and possibly wasting your time, Your Honor.
Mr. Alatorre, I appreciate that. Thank you for the apology. I would advise you that at this point, it's in your best interest to let Ms. Arnold do all the talking for you, okay?
All right, thank you.
Thank you, sir. Ms. Arnold,
We concede that you're a grown man, but you're also, well, you're a stupid man as well. And you've made that abundantly clear. Your attorney's doing fine. Shut your hole.
are you prepared to proceed with Mr. Alatorre's arraignment on the new charge?
I am, Your Honor.
Go ahead.
This is Sophia Arnold. Defense will waive a formal reading of the city's criminal complaint and ask the court to enter a plea of not guilty and stipulate to probable cause for today's purposes only. I have advised the defendant of his rights at arraignment, and after screening him, he is currently unemployed and does qualify for court-appointed counsel without a promissory note, and we ask to be appointed to his case. Thank you.
Thank you. Mr. Alatorre, based upon the record that your attorney has made, the court's going to waive formal reading of the criminal complaint charging you with assault in the 4th degree and malicious mischief in the 3rd degree, and will enter pleas of not guilty for you at this time. The next thing the court's going to do is turn to the prosecutor regarding the prosecutor's recommendation on pretrial conditions of release in your cases. Ms. Pace?
Thank you, Your Honor. I've had the opportunity to review Mr. Alatorre's history. Your Honor, he has multiple failures to appear out of this court, including the 2 for his SOC matter, as well as several out of other courts. He has 4 active warrants out of King County Superior Court and Kent Municipal Court. Your Honor, based on his failure to appear history and apologize.
Your Honor, I do not want to get out of jail. I don't know how much clearer I can make it. I do not want to get out of jail. I would like to stay in jail. I just want to get to the hospital from jail. Like I would like you guys to get to the hospital.
If you have anything to say, please request a breakout room with me before you say it, okay?
Your Honor, I'd also like to point out that he has pending charges for attempting to elude police officers and escape in the 2nd degree. Based on his failure to appear history as well as his pending charges, I'm asking for the court to impose bail in the amount of $1,000 in this case. I'm asking for the court to impose all standard conditions of release otherwise, and for his SOC matter to track.
Thank you. Ms. Arnold?
Yes, Your Honor. As the defendant stated to y'all, there is a serious health concern going on here. The defendant is suffering from a blood infection. He's supposed to be at the hospital right now. It started in his upper spine and it's just getting a lot worse. And it appears that he was released out of Tacoma in order to go get attention for this health concern, but was not able to. So we asked the court to consider this in their determination. If there's a way for him to get some medical attention while remaining in custody, that would be great. If not, we would ask that he be released on his personal recognizance to do so. Thank you.
Thank you. So the court notes that on cause number ending in 1685, Mr. Alatorre was before the court on January 22nd of this year and entered into that stipulated order of continuance. On the new charges, he is alleged to have committed 3 new criminal offenses approximately 18 days later in this jurisdiction. And so that coupled with the number of outstanding warrants and the prior warrant history, the court agrees with the city that release on pretrial personal recognizance is not appropriate in this case. Court is going to impose bail at this time. Court will impose bail under cause number ending in 0324, which is the new matter. The court will impose bail in the amount of $1,000 cash or bond. On the tracking matter, the stipulated order of continuance, the court will also impose bail in the amount of $1,000 cash or bond. The other conditions that the court will impose, Mr. Alatorre is to appear on time for all scheduled court hearings. His next hearing, if he is still in custody, will be Friday, February 21st at 11 a.m. The court is also going to order that he remain in contact with his attorney, and the court will appoint the Horwath law offices to represent him in this matter. I believe they are the attorney of record on cause number ending in 1685 as well. Given the nature of the charges under cause number ending in 324, Ms. Pace, is there a no contact provision that the city is seeking?
No, Your Honor. The facts of the case, given the facts of the case, the city is not looking for a no contact order at this time.
Understood.
Why are you gonna ask for no contact order? What, meeting the motherfucking...
Mr. Alatorre, there's no contact order.
I'm saying, I don't care about this. If you're not getting me to the hospital I'm supposed to, I don't want to hear about this. I'm good, Your Honor.
Mr. Alatorre, go ahead and hang tight. As I told you a moment ago, it's in your best interest to let Ms. Arnold do the talking for you. We're almost done with your hearing. But go ahead and just please be patient for a moment. Okay, the court has imposed those conditions. I'm going to go ahead and set an out of custody pretrial conference date as well. It will be scheduled for March 6th. Excuse me, March 11th. What time? At 1 p.m. So, Mr. Alatorre, if you're released, we'll see you back here on March 11th at 1 p.m. here at the Lakewood Municipal Court. If you're still in custody, we'll see you next Friday. You'll be continuing to appear from the Nisqually Jail at that time if you're still in custody. And the court has signed that order. Mr. Alatorre, thank you. I'm sorry that you're having some medical issues and you're not feeling well. I hope that improves. You can go ahead and let the officer know that your hearing is done.
Well, there you have it. Thanks again to Alyssa and Lokificent Lair for hooking me up. Those clips, sometimes this happens. I was otherwise occupied all day doing stuff, doing tedious stuff that I didn't want to do, but I had to do. So I get in and I just throw together a couple of clips. I'm thinking, whatever. We'll do a stream. But then on second review, when I'm going through the clips, I'm like, these are better than I originally thought. I'm enjoying these more midstream than I was when I was putting it together. It was good stuff. I guess I pick up more the second time. Yeah, that's right. I did some prep. I've been shamed by the musical offering sent to me, and I've decided to do prep for my streams. Okay, not really. Who am I kidding? Thank y'all for coming out. I'll see you soon.